As ready as my voice is going to be able to be read, Your Honors.
Whenever you're ready.
Okay, thank you. Good afternoon, and may it please the court, I would like to reserve 5 minutes for rebuttal. My name is Jason Ballinger from the Memphis Shelby County Bar, and I represent the appellant in this matter, Rashad Fair. This case is essentially about two things. One, whether trial court abused its discretion by denying the defendant's petition for diversion without properly considering the necessary factors or weighing them on the record. And two, whether the trial court violated its duty to remain impartial, or at least that to maintain the appearance of impartiality. Before I start, would Your Honors appreciate a brief recitation of the facts, or should I just go straight into the argument?
It's however you want to handle your argument.
Okay. I'll briefly go through the facts here. This is a case where Mr. Rashad Fair was charged with voluntary manslaughter. He pled guilty to voluntary manslaughter in February of 2023. This is an incident that goes back to May of 2017, where Mr. Fair was in a motorcycle club in Shelby County, and he decided that he wanted to get out of that motorcycle club for whatever reason. At that point, he notified the president of that motorcycle club, which was the decedent in this matter, Rodriguez Lucas, and they had come to a tentative agreement for Mr. Fair to return the center patch that was of some value to the motorcycle club, and then Mr. Fair had requested that Mr. Lucas return some of his club dues that he had already paid through the year, because it was only May of 2017 at that point. At some point, that agreement fell apart, and on May 26 of 2017, Mr. Lucas shows up to Rashad Fair's home uninvited with 4 other individuals. There is an argument right at the door of the back or side door of this of Mr. Fair's home between Mr. Lucas and Mr. Fair when there is video, but there's no audio, but you can tell there is an argument, and eventually Mr. Fair turns around, goes back into his house, and Mr. Lucas then immediately begins punching Mr. Fair in the back of the head. At which point, Mr. Fair, it's off video at that point because he's in his home, fires one single shot from a pistol that resulted in Mr. Lucas's death. After that, Mr. Fair put the gun down, stayed on the scene, and cooperated, gave a statement, and he was eventually charged with voluntary manslaughter and employing a firearm during the commission of a dangerous felony. The matter was set for trial at least twice. Because of COVID, it got delayed. I know you guys are sick of hearing that. But it eventually got set for trial. Ultimately, the state made an offer that Mr. Fair could plead guilty to voluntary manslaughter. They would dismiss his employing of a firearm during commission of a dangerous felony charge and petition the court for diversion. At that diversion hearing, proof was put on. Diversion was ultimately denied by the trial court, and the sentence was initially announced by trial court that for Mr. Fair to serve 6 months in confinement, followed by 2.5 years on probation. Once that sentence was announced, I, as trial counsel, requested that Mr. Fair remain out on bond pending an appeal because I believed his family would want to appeal this. The judge denied that request. I then informed the court the trial court that the statute, Tennessee law, establishes that he is entitled to remain out on bond for any felony sentence that is less than 1 year. As soon as I stated that, the judge said, and I quote, "Fine, 1 year then." Immediately changing Mr. Fair's sentence from 6 months in confinement to 1 year confinement after I had explained to her that the law entitled him to remain out on bond. That's as brief as I can make that recitation of facts. So moving on, I would just first point out, in the state's brief, they've already conceded that the trial court erred in sentencing Mr. Fair to the confinement and probation without actually having properly addressed any of the factors, and have requested that the matter be remanded for a new sentencing hearing. However, they obviously still disagree on the trial court's denial of diversion.
Why don't we look at that for a second? What exactly are you saying the court didn't follow in making the decision about the denial of diversion?
Okay.
What factors were not considered?
So-
What factor was not considered by the court?
You read my mind, Your Honor. I was going to that right now. So there's obviously in State v. King, Parker, and electroplating, there's those factors, those common law factors of amenability to correction, circumstances, offense, and so on. The trial court considered, put on the record some of those factors. She did not address deterrence, which is one of the factors enumerated in Parker and electroplating. But she also, the trial court weighed the circumstances of the offense, which I do want to address in some detail. The trial court held that, or determined that the circumstances of the offense of this matter were especially aggravated, and that she relied heavily on this factor, gave it great weight. However, the trial court did not state any reason based on any in the record or even outside of the record that actually amounted to any sort of aggravating circumstance of this offense. Essentially, in her recitation of the factor or the facts concerning circumstances of the offense, the only relevant factors that were mentioned were that there was an argument between the two, that there was a shot fired that killed the decedent. And then she starts speculating about what Mr. Fair must have said to make Mr. Lucas lose his cool, and then speculates again that, well, the gun probably wasn't in Mr. Lucas's view, without having even seen the video. The other factors that she addresses when she's talking about circumstances of the offense are those about her total disagreement with the availability of diversion for the offense of voluntary manslaughter, which at the time, even at the time of the hearing, was still available. And that she was shocked by the level of sentence that you would receive in that case. So that's what she considered in the circumstances of the offense. Did not consider the other circumstances of the offense that were clearly on the record, which were that Mr. Fair stayed on the scene, that Mr. Fair was inside of his home when this occurred, and I pointed out to the court that I believe this is a close case between self-defense and voluntary manslaughter because of the fact that the statute for self-defense says if you're inside your home and you're being attacked by somebody who's not invited, it is presumed reasonable to use deadly force. So did not consider that, did not consider the fact that Mr. Fair took responsibility or that he cooperated fully. Just determined, just sort of without any other explanation, that these circumstances were especially aggravated. And Your Honor, the state argues that the trial court gave great weight, and it was made the determination it was especially aggravated, and that was reasonable. But they don't give any reason why it was reasonable. Just that, well, the court says it, so that's enough.
But the court also looked at deterrence and looked at depreciating the seriousness of the offense.
Well,
And it went into a lot of comment about gun violence in Memphis, about readily having guns available, arguments turned into violence
Yes.
and death, and also commented on your client's cavalier attitude that she felt like didn't really take it seriously. She made findings on the record on those topics.
And Your Honor, the state in their argument, or in their brief, did address those, but for one, in the court's ruling, she did not address deterrence. She had addressed gun violence issues in her cross-examination of Mr. Fair during the proof portion, but she never stated any sort of deterrence issues when she was making her ruling. As far as...
She may not have said the word deterrence, but she talked about how in Memphis, the easy availability of guns, you have this problem where someone gets mad and someone gets killed.
And I understand that, Your Honor. However, those were statements that she made during the middle of questioning Mr. Fair, which are not part of the ruling, and did not specifically address deterrence and what weight she would have given that. As well as, Your Honor, as far as deterrence for this, State v. Hooper is the case that kind of mostly people talk about when it comes to deterrence. And I know that's, I won't go into all of those factors, but they do talk about what deterrence factors, or what type of cases are, or crimes are deterrable, and those that are intentional, knowing, or reckless, and that type of behavior. But they specifically state that offenses that are part of a induced passion, basically they use similar language to that of what voluntary manslaughter statute says. They said that's not really something that will be deterrable by heightened sentencing, and I've addressed that in my response to the state. As far as the interest of the public factor of the electroplating issues, the state doesn't point out anything that really actually pertains to depreciating the seriousness of the offense or the interest of the public. Judge Skane never said what the issues, what the interest of the public was to denying it. She just said it goes against the interest of the public. The state wants to argue that the court's finding that Mr. Fair was cavalier or did not take it seriously was part of this factor, but they use the word implicitly found, which I also addressed in my response, which is if we're allowing courts to implicitly establish these common law requirements on the law, which are on the record, that cuts against the purposes of the case law that we have, which was to ensure the consistency in sentencing, as well as to make it easier or more readily apparent what the actual review issues are. When we're saying that, oh well, the judge kind of address this here and kind of address this here without stating it specifically, that leaves us guessing. That leaves the defense guessing, that leaves the state guessing, that leaves this court guessing, essentially, at what the court's intentions were, the trial court's intentions were when the clear requirements under the law are to avoid that by stating it specifically or stating it at least clearly on the record, not
Mr.
implicitly.
Ballinger, she was shocked and said so, that somebody who was charged with voluntary manslaughter could even receive diversion, right?
Yes.
Okay. And whether that's disagreement with the legislature or whoever, I mean, am I correct, like today, the legislature has agreed with her if this offense were to happen today, right?
That's correct.
Okay.
That law was changed in July.
So in the implicit or the undercurrent of her comments, is it your position that we cannot look at the comments as a whole, as the state has, and say this supports this factor? Or is it your position that she is supposed to say the magic words and tie each factor independently to an additional finding in the case?
What my position is, Your Honor, and thank you for that question, is that, one, in a ruling by a trial court, they must abide by what what the case law or statute says. And if they do not, then it is almost impossible to determine what their intentions were.
But the case law doesn't require magic words.
It does not require magic words, but it requires some words. It requires something to be placed on the record. By the reason why these cases exist is because just saying, well, I looked at it, we're denying diversion, was not enough because it does not clearly establish why. And so they have to establish what factors that were considered and what weight was given to those factors. And when you don't state that, you just say, I considered them all, I'm denying diversion, I'm not asking for magic words, I'm asking for any words. And there's just no words to determine what factors she considered, what factors she weighed against each other, and what weight she gave to each one. And at that point, it cuts against the entire reason for these cases to exist and the requirements for a judge to put these factors on the record. If there's anything else I can sit down.
Thank you.
Thank you.
May it please the court. Good afternoon, Your Honors. Davey Douglas on behalf of the state. This court should affirm the denial of judicial diversion, but the state concedes that the court erred in denying probation and imposing a 1-year sentence of incarceration, and that the case should be remanded for the trial court to make those appropriate findings. But turning to the issue of diversion, I think where the parties all actually agree is that the trial court is not required to state magic words in both reciting the factors applicable to judicial diversion and in reciting the weight that it gave to those factors and how it applied them. What we have to do is look, and Judge Wilson, I believe you pointed this out, look to sort of the trial court's comments as a whole. And what we have here is the trial court concluding that judicial diversion was not appropriate based on the circumstances of the offense and the need to avoid depreciating the seriousness of the offense and for the deterrent effect that denying judicial diversion would have. And the fact that the trial court may have made comments indicating that there was the need for deterrence earlier in the hearing, it doesn't prevent this court from considering them and considering them in context, which is where the court was putting its findings on the record that there was a need to deter gun violence in Shelby County. And then similarly, the court's comments about the defendant's attitude go directly to the factor of needing to avoid depreciating the seriousness of the offense. The court stated on the record that it found the defendant's attitude very cavalier and that he seemed to expect that he was just going to come in and receive diversion or probation. So again, that's what this court can look to and conclude that the trial court rightfully weighed the deterrence factor.
But finish your thought.
Just that it rightfully weighed the deterrence factor against the other electroplating factors.
Well, but while there are no magic words, they are required to review every factor. Did she review every factor?
She did not explicitly say deterrence was a factor that she reviewed, but she identified the remaining factors.
Okay.
And again, what this court has said is that trial courts are not required to explicitly and specifically state the weight for each factor, but it just needs to create a record showing that the court considered the factors, which is what the court did here. It even found, after reciting the factors, that some weighed in favor of judicial diversion. But the fact that the court then denied diversion shows that it conducted the weighing of these factors that it was supposed to do. And the record fully supports the court's determination here that the factors did not weigh in favor of judicial diversion. And it was also proper for the trial court to sort of make its own findings and inferences based on the proof presented at the hearing about the defendant potentially saying something that set the victim off. That was the only proof of what actually happened was the defendant's testimony, and the trial court found that that was not necessarily credible, that it didn't believe that the defendant was going back into his house to receive the motorcycle patch, which was well within the court's purview and discretion as the finder of fact. And again, the court is not required to specifically and explicitly state every factor. It's enough that there is a record as a whole showing that the court considered these factors, and that's what we have here. And I know the court stated on the record that it did not think that judicial diversion should be available for a voluntary manslaughter conviction. The court did say that, but that statement alone does not show that the court was somehow biased against the defendant or was unable to thoughtfully and carefully consider whether judicial diversion was appropriate for this specific case, because the court, again, it articulated all but one of the relevant factors, and it proceeded to consider very specifically the circumstances of this case. And this sort of bleeds into the third issue that we didn't get to talk about too much. So I would rely mostly on my brief for that, but just argue that the trial court's statement there was not a demonstration that it lacked, that it was no longer impartial, and that it was sua sponte required to recuse itself from the proceedings. This was just the trial court making one statement, and then later there was a tense exchange between counsel and the trial court.
And I'm not saying I disagree with you, but I mean, the Code of Judicial Conduct talks about, just like the ethics rules for lawyers, it talks about the appearance of impropriety, and it talks about protecting the integrity of the judicial system and those types of things. So saying I disagree with the legislature and this never should be divertible and all those things, and then denying diversion, does that not hint at at least the appearance of someone who's prejudged a case or who is not necessarily resolving a case even-handedly?
Respectfully, no, Your Honor. I don't think that it necessarily does, because again, we have to sort of look to the whole context of the trial court's statements here. And what we do have the court saying is, I don't think that this should be available for voluntary manslaughter. But we also have the court considering individually all but one of the enumerated factors for judicial diversion and not making blanket statements or blanket findings. It made very specific findings to this shooting. That's what it confined its analysis to, which demonstrates that it was being impartial when it considered whether to grant or deny diversion in this case. And the fact that the court was able to consider the specific circumstances of this offense sort of distinguishes this case from Cook versus State.
Oh, I agree. This isn't a Cook case. I agree with that. Okay.
But I certainly understand the concern, Your Honor, and I do think here that the trial court's just sort of that one observation does not rise to the level of showing that the court could not be impartial.
What about the issue about the bond setting and then changing the sentence? That was,
I mean, the scale starts to tip at some point.
yeah.
I certainly understand that concern and the way that the scale does start to tip. And I think it is important, though, to sort of look at those comments as what they were, which was just a very brief, tense exchange that also possibly came on the heels of the court directing counsel to sit down. And it was a very quick exchange, which...
Let me ask you this. Can we just re-sentence? Like, you've conceded that the denial of probation or the terms of the sentence are improper, or were not correct, or need to be reviewed. Is there enough here for us to do that on our own?
This court does have that authority, but I don't think that this would be the proper case to exercise it because we really don't have that much of a record here. Like, for example, we don't have the pre-sentence report. It was considered.
I asked that based on the heels of these other questions. I mean, you've got a trial judge who clearly doesn't believe this is a divertible offense. I'm not saying that not going to follow the law, but has made the statement, this is not divertible. And then when they ask for an appeal bond, because they're within that range that allows for it, immediately changes the sentence to a sentence of 1 year. Rather than remand it to that trial judge or remand it to a new trial judge, would it not be more reasonable for us to impose it? But you're saying we don't have enough?
I think that if this court absolutely could consider it, and there's certainly similar factors that weighed against judicial diversion that would also weigh in favor of a sentence of incarceration here. But what this court has also said is when the trial court doesn't make those explicit findings and doesn't conduct the proper analysis, the best course is for a remand, to give the court or give a trial court a chance to do that analysis. And so that's, again, why the state would submit that remand would be the best course here. And unless there are any further questions, we would ask this court to affirm the denial of judicial diversion and conclude that the trial court was not sua sponte required to recuse itself. Thank you.
Thank you, counsel.
Thank you, Your Honors. I would just, to respond to some of this issues that were addressed by the state and some of Your Honor's questions. One, I'll start off with the idea that stating very clearly that the trial court is totally in disagreement with the availability for diversion for voluntary manslaughter, and that it is shocking that the offense itself only carried the 3 to 6 years in custody. I cited in my response to the state v. McKim, which was an issue with pretrial diversion, but as it's been pointed out numerous times that they're treated very similarly. The ADA in that situation also considered all the factors, but also stated when denying pretrial diversion for negligent homicide back when that was available, stated that it was an aberration of the law and that the legislature should remove it from eligibility. And the court said, the Supreme Court said that the ADA focused not on the diversion factors, but rather his own opinion of what should and should not be a divertible offense, and that the tone of that ADA, his written denial suggests that he will not grant pretrial diversion to any defendant charged with criminally negligent homicide. So just because the court did go through some of those factors, and lightly so, the fact that there's that statement from the get-go that she was so opposed to the availability of diversion for voluntary manslaughter, I think is right within what the Supreme Court's ruling in State v. McKim. As far as whether the court lacked impartiality for when increasing the sentence. A tense exchange between trial counsel and judges is not anything new. Judge Campbell, I'm sure you and I back in the day had accidentally maybe had a little tense exchange. Probably not, but I was much better behaved in your courtroom. I know that. But there are remedies for that. A trial court could say it could hold me in contempt. Trial court could issue sanctions. Trial court could do a number of things, or nothing. But to then take that out on the defendant it arises to a level of an appearance of impartiality that the standard is that a person of ordinary prudence in the judge's position, knowing all the facts known to the judge, would find a reasonable basis for questioning the judge's impartiality. When you're doubling someone's sentence of confinement based on what his trial counsel said, which was an accurate statement of the law, and then going further and saying, if you keep talking, Mr. Ballinger, it's going to get worse. So then effectively removing his right to counsel. So that entire statement, and then Judge Dyer, you said that you don't believe this is a Cook case. And I understand there's obviously some distinguishing issues there, but Cook is very on point when it comes to, if you have all these comments, you have these statements by the trial court, then you start looking at the totality, the entire record, and the statements and the attitude, the actions of the trial court. And so when you review Cook under that, you can see that many of the comments, the fact that when I'm when I'm direct examining the defendant about his social history, the judge cuts me off, says, "What's the point of that?" Well, the point of that was social history, which is a specific factor. And I list out in my initial brief all of that. But so those issues, Your Honor, I think are why Cook is relevant, is because you can review the entire record when there's so many statements that were problematic. My time is up.
Thank you.
Thank you.
We will take about a 5-10 minute recess and then resolve the preliminary matter.
All right.